All right, good morning, and welcome to the District Court of Appeal for the 5th District. I've been introduced. To my right, your left is Judge Orfinger, and to my left, your right, is Judge Cohen. We've got 3 cases today. We're going to take them in reverse order. The last one first. Just kidding about that. No, you're first, sir. I was just. So the first case we have on the docket today is HI-SHEAR Technology, and I assume that you're here for the appellant, sir.
That's correct. Donald Christopher, Your Honor.
You may proceed.
Your Honor, can I reserve 10 minutes, please?
Sure. There's a clock on the podium there. I'll try to help you with that if I remember. So.
Thank you. I'm Donald Christopher. I represent the appellant today, HI-SHEAR Technology Corporation. I come before you due to a grave miscarriage of justice suffered by HI-SHEAR. The appellee, United Space Alliance, was able to mislead a jury during 9 long weeks of trial in the summer of 2005 into taking away from HI-SHEAR everything it deserved, giving it nothing, and this all as a result of multiple cumulative errors of the trial judge. The case involved a contract dispute. Space Alliance is a joint venture of the 2 largest aerospace companies in the world, Boeing and Lockheed.
You have a number of issues that you're going to want to present to us in a relatively short amount of time. You should assume, for the sake of the discussion, that we are familiar with the facts of the case, that we've read the briefs, and start going immediately into the issues that you think are most important.
Okay. In order to avoid responsibility for paying HI-SHEAR what Space Alliance owed it in this case, Space Alliance contended that HI-SHEAR...
Can I stop you there for a minute, and maybe you can help me understand. I'm trying to get a little macro here, if I can. What was, did they pay him for the 17-second cutters?
No, Your Honor.
Okay, so you shipped those on the 7th of April of 2000 after the meeting.
Yes, sir.
How much money is involved there in just those reefing cutters?
I apologize to the court. I don't have all those numbers in my head. It's several $100,000.
Okay, but that shipment was received by them. Those goods were not rejected. Ultimately, they were incorporated into whatever they do with them. Is that right? They
used them for whatever. That's correct. But more importantly, if you recall, there was 3 bolt contracts, and we had...
I wanted to ask you about those too. What was the status of the bolt contracts as of May 17th, which was the date that they purportedly terminated all the contracts?
We still had invoices outstanding on those bolt contracts.
Okay.
And those bolts had been delivered.
And those invoices were outstanding as of the April 6th meeting in the hotel?
Yes, we had other invoices that were outstanding then. Those were the invoices that were sent in February, and those were the invoices that United Space Alliance specifically said, we're not going to pay until you ship reefing line cutters.
Right. Now, so on those, I guess you don't know the math on those, but the $57,000, which PO did that relate to?
That related to one of the bolt POs, and that was only...
After or forward? Mr. Kahn
my co-counsel tells me forward, but
okay.
That was only part of that invoice, and where that number came from, it came off of an interrogatory answer that was basically taken out of context that listed a whole bunch of numbers, and that was just one number. I think
Well, that's what the jury found.
That's what the jury found, exactly. But it was on incompetent evidence, though.
Well, you're kind of stuck with your interrogatory answer, though, if they believe it, right?
No, you have the contract specified the measure of damages.
What error did the trial judge make that resulted the fact that evidence was presented to a jury, including interrogatories, and the jury made a finding that the damages were $57,000? What error did the trial court make? What error did the trial court make? Yes.
The trial court made an error in not properly instructing, in accordance with the contract, what the damages should have been. The contract provided not just damages to what's outstanding or owed on invoices at the time, but termination damages under the federal acquisition.
That depends on whether it's a cause, termination for cause, or whether it's characterized in some other manner, and the jury apparently found against you on that issue.
That's right, and they found against us on that issue because a defense was allowed to go to the jury that should have never gone to the jury on this Hobbs Act claim.
Right, so the error relates back to the Hobbs Act.
Certainly.
That's your position on the $57,000 damage?
No.
That's the error?
Well, it relates back to the Hobbs Act, yes, as far as liability goes, but it also relates back to the contract. There's no contractual basis for that $57,000 number.
Because the $57,000 number that was awarded, the Hobbs Act didn't apply to that element of damage, as I understood the record.
Exactly. But the judge allowed that number to go to the jury as a possible number of damage, and there was no credible basis in accordance with the evidence under the contract. That number, we could pull any number out of the air.
Allowed it to go back in what sense? Allowed an argument to be made that that's what the damage was by counsel?
Yes.
Based upon interrogatory answers?
Right.
And you all argued otherwise.
Right.
So my question goes back to what was the error that the trial judge made? If the jury got it wrong, in your opinion, it's nothing that we're going to address.
No, the trial judge should have never let that information on that interrogatory go to the jury with respect to that element of damages.
There was an objection to that?
Yes.
What was the objection? Relevance?
Yes, Your Honor.
All right.
Going back to
Let me ask you another question. Did the defendant have the right to accelerate the completion schedule for the 17-second cutters?
Sure, it had the right pursuant to a valid change order, but it didn't attempt to do that.
What about that open work authorization? Tell me about that.
That open work authorization, Your Honor, all that did was it gave HI-SHEAR the option, if it wanted, to go ahead and ship those cutters without being flight certified. HI-SHEAR was not willing initially to do that. If you recall on the record, they had done that once before, a year before, and then there was a big delay in the flight certification, and that's one of the reasons that HI-SHEAR was holding those cutters, because they hadn't been flight certified, because flight certification took a joint effort of both Space Alliance and HI-SHEAR. And HI-SHEAR's concern was that if they allowed those cutters to leave their facility, that somehow they might find their way on the space shuttle. If there was a problem with the space shuttle, ultimately it'd come back to them.
And virtually immediately after the meeting that occurs, your client ships these, correct?
Correct.
After telling them that if I get the thruster contract, we get the thruster contract, we'll go ahead and ship them.
Exactly.
But
And again,
really, that's what you just told me was kind of your theory of the case, that the motivation for not shipping the cutters was because of this certification issue, but their theory was that the motivation was that they wanted to extort the defendant into signing the thruster contract, right?
that was certainly their
theories.
That was certainly their theory, Your Honor, but the key word there is extort. And in any contractual situation, the classic case is a construction contract. You've got one side wanting to do something and one side wanting to do the other. You bargain back and forth for performance, increased performance, changes, varied performance, and so forth.
Does your hard bargaining theory rely upon some legal right to that contract?
I don't understand the question.
The legal right to the contract for the booster, the parts for the booster.
You mean for the bonnet thrusters?
The bonnet thrusters.
Well, certainly we had a legal right to that contract.
Why did you have a legal right to that contract?
Because of the fact that it had gone through the normal procurement process. We were the least costly, most responsive
Does
bidder.
that give you a legal right? Just because you're the low bidder doesn't mean that you're going to be awarded the contract.
No, that's true, but there would have had to been some exception in the process or some reason not to give us the contract. All the responsible contract officers who had no knowledge of all this extortion falderall looked at that and determined that we were due to be awarded that contract. And the only reason it was delayed was because the other procurement officer, who was unrelated, Mr. Wyzik, who was out to get my client, put this quality hold, this pretextual quality hold, kept it on for so long, when basically the 17 items on the quality hold we'd already checked off and satisfied months before. So did we have a legal right? No. Could we have gone in and sued for the contract? No. But in terms of a legal right, I'm saying it wasn't that we were just demanding a contract to them that we weren't otherwise entitled to. I'm saying that all other things being equal, we were entitled to receive that contract. We were qualified. We fairly bid it. We bid it, in fact, 2 times. We'd spent substantial money in the bid process.
But within your brief, you keep talking about this as a legal right. And I'm not understanding why you think you had a legal right to that contract.
Because, again...
Just because you were the low bidder.
You had no greater legal right than any other responsible low bidder. Is that correct?
That's correct.
And with respect to your Hobbs Act dispute and the hard bargaining issue, were you allowed to argue to the jury this wasn't extortion, this was just hard bargaining, and likewise were they allowed to argue to the jury that this was extortion and improper bargaining?
That's certainly true, Your Honor, but in my argument, because of the way that the evidence was excluded, my hands were tied behind my back. First off, I wasn't allowed to admit the declination letter from the U.S. Attorney. And
why would the U.S. Attorney's decision that this might not rise to the level of a crime be relevant? I mean, that's his opinion. He's a lawyer who represents the government, but certainly has a different purview than the people who are building the space shuttle. Why is his opinion relevant to the issue of whether or not this was improper contract negotiation?
Because the people that were building the space shuttle, that's the second element I was just getting to, the people that were building the space shuttle contended that it was somehow contrary to the FAR's, Federal Acquisition Regulations, to condition performance under one contract on receipt of another contract. That was their basic theory. Only problem was there's nothing in the FAR's that says that. And I requested an instruction from the trial court from that. He refused to give me that instruction.
Getting back to the question that was asked, which was about the decision of an assistant U.S. attorney. You were an assistant U.S. attorney at one point. Had the U.S. Attorney's Office made a decision and indicted, but your client had not been convicted, would that have been admissible?
Certainly. If you look at the record, when you look at the record in this case,
Can you tell me what evidence rule would permit that? The fact that under Judge Cohen's hypothetical, what rule of evidence would permit the fact that your client had been indicted and conversely that their client, or that they had declined prosecution? Can you tell me what evidence code section would authorize that or cite me a case?
No, I can't provide you an evidence code section, but I can't, at the same time, I haven't been cited any case that would exclude that evidence, and it seems to me highly relevant on the question of was there
How does that reflect anything other than the opinion of the U.S. attorney that is looking at it?
It doesn't, Your Honor, but that opinion the jury was entitled to know and consider that opinion.
Well, but the jury wouldn't understand probably that the burden of the prosecutor would be a good faith basis to believe he could get a conviction beyond a reasonable doubt, which is substantially different than the burden we've got here.
Exactly. So in which case that would mean there wouldn't be a violation of federal law, which would mean that there wouldn't be any entitlement to declare a default under here under the theory that Space Alliance used.
So is it your theory that the Hobbs Act defense should not have been put forward unless they were able to prove extortion beyond a reasonable doubt to the criminal standard?
I think the standard that we argued and that the case law in Florida requires under Chapter 772 is clear and convincing evidence that the mirror defense that they had of duress, the reason that they repudiated the bonnet thruster contract and repudiated the nondisclosure agreement was duress, and duress requires clear and convincing evidence. And
This
so
wasn't
that's
an action brought under 772. This was an affirmative defense brought as part of a civil action.
right. But if you read 772, it talks about that if you're seeking civil remedies for any enumerated criminal statutes, that clear and convincing evidence is required, and the Hobbs Act is one of the criminal statutes included in there. If I may, I'd like to reserve the rest of my time.
Certainly may.
May it please the Court, Michael Levin of Baker & Hostetler, representing United Space Alliance. Where to begin?
Let me begin you with the hypothetical that counsel was about to get to, which was, your classic construction scenario. Let's say it's somebody on the critical path that's supplying structural steel, and they get into a dispute with the contractor. Subcontractor gets in a dispute with the contractor over a prior billing, an amount. Maybe they've called it an extra. Maybe they're in a dispute over whether something is an extra or not, a design change or something. And the structural steel subcontractor demands payment. They refuse to make the payment, and he says, "Okay, I'm not delivering your steel," which of course is going to, set the project back and possibly even, put it into bankruptcy. Is that extortion or attempted extortion? Assuming it's in interstate commerce, I understand that's an issue, but.
No, and that is not extortion. It depends. Your hypothetical would require...
Well, let's say he's not entitled to, let's say the subcontractor is not entitled to the money. He thinks he's entitled to the money, but he's not entitled to the money. So he wants to get money that he's not legally entitled to under the contract, and the contractor won't give it to him, and he says, "I'm not going to put the steel up."
I would think the hypothetical is incomplete. If the contract did not permit the steel contractor to withhold a direct instruction to ship the steel and install the steel, and if the contracting party was not just another construction contract, but it was let's say a national defense critical situation, or there was some sort of extra contractual consequences whereby some dire circumstance would arise. Mr. Herring correctly capsulized the...
Well, I'll change the hypothetical, and I'll include that there's, the contract is totally silent on the subcontractor's right to withhold performance, the contractor, though, if they are not able to complete the schedule, complete the project on time, is going to go bankrupt. So it's extremely important to the contractor that they get the steel in a timely manner. Can that be an extortion case?
No, sir. That is...
Because it's got to involve the shuttle in order for it to be extortion?
This involves the shuttle.
I know, but at my hypothetical, though, what's missing in my hypothetical? Why would that not be extortion?
It's not extortion because it doesn't have the elements. It doesn't have the elements of fear. It doesn't have the element of the wrongful actions taken, and it doesn't have the elements of property.
Well, the fear is the same as in this case. The fear is an economic fear, that if we don't get the steel, we're not going to be able to finish the project. We're going to go bankrupt.
Well, I think you're really describing the Suris and the San Francisco cases, are the two cases that have been cited by the other side and distinguished. Those are single contract cases. The fear is not, that we demonstrated, was simply not that the fear that could be remedied by a breach of contract. It's not the sort of fear that is inherent in the contractual relationship. The fear that's in this record that was capsulized by the testimony both of Mr. Herring and Ms. Close was they would not receive the cutters. They would jeopardize the return to shuttle flights. They would jeopardize the space program. It is really an application of for want of a nail, the battle was lost. Poor Richard's Almanac, 1758, and cited by every American general since. That's what this situation is. This situation was a America has commitments to the space shuttle, America has commitments to the space station.
Well, hold on. Although it's interesting that this contractual dispute involves the space shuttle, it really is nothing more than just a contract dispute at the end of the day.
It is not just a contract dispute when they are exploiting our fear, not of not getting paid.
Well,
that was not the fear. It was not just.
But that's an ordinary. I mean, that sort of situation arises in just about any contract dispute. I mean, following up on Judge Torpy's hypothetical, it seems to me that if there's a difference in his hypothetical, it relates to a dispute over the performance of one discrete contract. And here, the argument being made, if I understand it, is we won't perform. There's no substantial argument over the performance of contract one, but we won't perform contract one unless you award us contract number two.
Yes.
And that seems to be a distinguishing factor. But let me ask you about the
contracts 2 and 3.
Right. Let me ask you about the reef cutters. Those were received, correct?
The reefing line cutters were received, yes.
And how do you justify the $57,000 figure? I mean, there was no dispute over the quality of those.
That's not the reef cutter. That's not the reef cutters.
$57,000 was the forward bolt. That was an unpaid invoice in the forward bolt. What
about the reef cutters, though, since Judge Orfinger's asking about that? How do you get away without paying for goods that were shipped and received and accepted?
Let me respond to that. There's several absolute clear bullet reasons why that's a non-issue in this case. Number one, they traveled on a termination for convenience damage theory. Termination, it's a binary situation. If you terminate for default and a default is not found, it's automatically converted into
paragraph. Who's they? You mean
if United Space Alliance terminates for default, if USBI under the predecessor contract terminates for default, and that default is proven to be unjustified, it's automatically terminated for convenience. There is a measure of damage for termination for convenience. These are not invoices specific to a batch of cutters. They are a progress payment. If you look at how damages are calculated, if payments are made, they're a deduction from the damages that they're entitled to, because they're entitled to receive their costs.
I'm sorry, but I know you want me to understand what your response was. I thought the jury found that the termination was for default.
Yes, sir. Yes, sir.
I go to termination for default in here. Doesn't it say that you got to pay for completed goods that are received and accepted?
Let me go to those two responses to that one. On termination for default, they took the position. HI-SHEAR's position at trial was if it's terminated for default, they get nothing.
Well, their expert said that.
Well, that's their expert damage. That's their expert, and understanding.
Are you saying that they waived it?
Yes, sir.
They waived it because they never presented that as a theory. They never argued it to the trial judge or to the jury.
Yes, sir. Even when the jury came back with a question and asked, what are your damages? The numbers they gave the jury on the very last day after they were deliberating were the same numbers for termination for convenience from their expert. They can't have both the invoices and the termination for convenience. That's double dipping. They chose the horse they're riding on termination for convenience, on termination for default.
But it is true that if it was a termination for default, which apparently it was because the jury ruled with you on that, they'd be entitled to be paid for completed work, right?
No, the contract really says is that there's supposed to be a settlement process. We engaged in that settlement process. We wrote them letters, and these are exhibits and evidence in the month after the termination in the year 2000. And it's supposed to be a calculation of what we owe them for unpaid invoices, less what we have to incur for procurement costs. They wouldn't respond to our letters. That's supposed to be worked out in a settlement process under the FARs. They deliberately refused to engage in that process, so they waived those payments in that respect as well. They waived it by the theory of the case they chose. They waived it by refusing to respond to our settlement letters. Settlement in the FAR sense. So those issues, the damage issues, if they ever pled it, they never pled it, they never presented evidence, they never pursued it, it's waived.
Would you explain to me how it is that your client was, I'm looking through this statute, I understand that your theory on the property of another is that it's an intangible property, the new contract, right? And
The property theory is the right to conduct business unfettered by fear. The right to conduct business and solicit business.
Well, I guess what I want to know is what was your client induced to do by the fear?
Sign the bond thruster contract, sign the mutual non-disclosure agreement.
Okay, but at the time your client signed that and those two documents, your client had no intent to fulfill either one of those, right?
Well, certainly the act of the extortion is a violation of the Hobbs Act. The intent to extort is a violation of the Hobbs Act as well. Secondly, we certainly, if there was no other choice, we would have had to have gone forward to it because we needed the bonnet thrusters.
So was your theory, was the jury instructed on an attempt to extort or on an extortion?
The jury was instructed on what the elements of the Hobbs Act were. On what property means, what fear means, what intent to exploit that fear means. They were instructed on the elements of the Hobbs Act.
But this is really an attempted extortion, right?
Well, it's an extortion.
But you really weren't, I mean, when you go to the government, when the threat is made to induce some reliance, and instead of relying on that or being induced, you go to the government and you report them, and then the government supervises everything that goes on after that. It's really hard to say that there was a completed extortion, right?
Well, there was a completed extortion within the elements of the crime. There was...
Only because your clients, under government supervision, wearing a bug, went in there and signed the documents, but they had no intent to perform, right?
A government prime contractor shouldn't be deterred from cooperating with the government in an investigation.
I understand. Your client had no intent to perform either one of those documents when they executed them and delivered them in the hotel room on April 6th, right?
My client hoped that law enforcement would intervene, but my client would have complied with those contracts if necessary to get those cutters and put those cutters to keep flight schedule. They were there in that room because they were extorted to be
Wasn't
there.
there testimony on the record that they never had any intent to fulfill those contracts? Those obligations?
There was testimony both ways on that. There wasn't what they've called attention to is the testimony where he said, well, I was told to sign these documents. I was ordered to sign these documents by the inspector, Mr. Schoper. They've cited to the evidence in the record that Mr. Herring was uncomfortable doing so. But you also have the actual transcript in the record where he says to Mr. Sallet, "Are you saying the only way I can get my cutters and bolts is by giving you the bonnet thruster contract?" And Sallet says, "Yes, it is." And he says, "Here you go." Now that's extortion. And the reason why he was there, the reason why they were mobilized like this, was to get those cutters, and the cutters came the next day.
It's extortion if he was induced to do it by fear. At that point, I don't see how your client could have been induced to do anything by fear when the government is monitoring the transaction.
Well, there was fear. It was economic fear because he didn't have the cutters. The cutters were not there. On April 6th, delay in flight schedule was a distinct reality. There were no more cutters in the shed. The company had the fear. Ms. Morton Close, the program manager, had the fear. That's what sent Mr. Herring into the arms of the U.S. Attorney's Office and the Inspector General. That's what sent Mr. Herring out to California.
Was your client on April 6th? Was your client did it have the contractual right to insist on immediate delivery of the 17-second cutters?
Yes, sir.
And tell me how that is. Was there a date for completion in the contract?
They were long past dates of completion. The fact of the matter was, under an open work authorization, they had the power to direct the cutters to be shipped. The cutters were completed. The testimony is that the cutters were being held hostage by HI-SHEAR on the dock. There was nothing that needed to be done to those cutters from a manufacturing standpoint. They were ready to be installed in space.
Certified.
The certification had to occur by USA and by NASA because they had to clear all of the errors that had been made in manufacturing the cutter from an engineering standpoint had to be dealt with by USA people and NASA people at an engineering review board to conclude that those errors had not infected this lot of reefing line cutters. That was a administrative and procedural process solely on the USA side of the table. HI-SHEAR had nothing to do with that other than opening up their file drawers so that we could have traceable copies of where they got the metal that went into the cutters and where they got the pyrotechnic powders. HI-SHEAR's work was done long before April 6th. They were done on March 15th. That's why the open work authorization was sent, because the quality assurance representative on site knew that those cutters were ready to ship. And they were being deliberately held. The testimony of Sherry Orth, the former employee, they were being held hostage. You have the handwritten notes. Hold until we get the thruster contract. You had the handwritten note from Mr. Trahan. Release, okay to release the bolts and cutters on April 7th. They were shipped on April 7th.
When did they default on the contracts?
The default was the commission of the violation of the Hobbs Act, the violation of federal law.
At the April 6th meeting?
Yes, sir.
Is that the date of default?
I would say that was the last date, all acts necessary to it. I believe they were in violation of the Hobbs Act, starting with the if-then letter in December, the meeting in January, the March 15th voicemails from Mr. South, all were violations of the Hobbs Act.
That was the outside date of that was the culmination of the default.
Yes, sir.
April 6th. Now, why didn't you terminate on April 6th?
Because we had to get our paper out of there.
You had to get your...
In order to, there's something called a Phase 3 review. Mm-hmm. The Phase 3 review is so there is complete traceability. And while the cutters were able to be installed in the stack of the solid rocket booster in the parachute assembly, they needed to gather up the invoices from the metal supplier and the invoices from the pyrotechnic supplier and the build paper to show how those components were put into the actual cutters. So there's complete traceability on every part of the space shuttle assembled into notebooks that are kept. That's the Phase 3 review. We had to have our people go out there and complete that Phase 3 review to assemble that traceable paper. Once that's done, and that also includes the rationale for closing out every problem.
So you didn't withhold declaring that the contract was terminated in order to receive shipment of the reef cutters. That wasn't the purpose.
The declaration of default was not done until the paper necessary to do the certifications was obtained.
If the reef cutters, if they defaulted, if they breached on April 6th, what is the effect of your client accepting performance after that?
They didn't accept performance. They went out there themselves and photocopied paperwork.
Didn't they accept the delivery of the reef cutters after April 6th?
The breach was not in the quality of the delivered good. The breach was in the conduct in violation of federal law. Had we chosen to declare a breach based upon quality issues and performance issues, they could have declared a breach a long time ago. Instead, it's a really big deal to terminate a supplier. There's a long history with HI-SHEAR. It took something like this type of conduct to terminate HI-SHEAR. But there's no, under the principle you're talking about, there would have to be, acceptance of the goods that are allegedly defective would be a way. There was no defect in these goods. These goods were good to go.
Would you briefly address the burden of proof issue discussed by the appellant?
Throughout Florida jurisprudence, you have civil actions based upon criminal conduct where the burden of proof is greater weight of the evidence. You have the Slayer statute.
Counsel, we're going to give both sides an extra 2 minutes. All right, so you
yes, sir.
Can run
Thank
over
you.
by 2 minutes.
Thank you. You have the Slayer statute. You have arson cases in insurance contexts. You have the case we've cited in our brief wherein under a civil theft claim, if you want to get treble damages, you have to show clear and convincing. But just the compensatory damages, untrebled, that's a greater weight of the evidence situation for a criminal act. Nowhere can they point to, in Florida jurisprudence, a regular civil cause of action for breach of contract, like in the arson situation, the Slayer situation, or this? Do you have that heightened burden of proof? It's not statutorily mandated. In absence of statutory mandate, you don't have it. I would like, unless the panel has other questions for me on some of these issues we've spoken about.
Go ahead and wrap up. Go ahead, sir.
I would like to just also address briefly the subject of attorney's fees, because we do have an attorney's fees motion. That may be gilding a little bit. I apologize if it is. But just to point out to the panel, there is a provision in the contract. It does entitle the prevailing party, USBI, under the terms of the contract, to seek attorney's fees for enforcing the terms and conditions of the purchase order. We enforced them below, we're enforcing them here, and that's the basis for our attorney's fees motion in this court. In this case,
Did you get attorney's fees below?
there's been an entitlement order, there's been a trial on amount, it's been fully briefed, and we're awaiting a decision from Judge Moxley on it.
Is the entitlement do we have that issue yet?
That issue's, no.
You're just saying that whether we have to decide it in the context of whether we grant appellate attorney's fees.
On the motion, yes, sir. Yes, sir. This is a situation, it is not by any means a standard breach of contract case. It is not hard bargaining. It is where
is the argument on entitlement whether or not you brought an action?
The argument on entitlement is that
if you, I guess you're the successor to USBI in the event USBI should bring an action for enforcement. Is that the argument? Or what?
Yes, and we have a counterclaim that we sought to enforce the provisions of, and we prevailed in the counterclaim below. We have a cross appeal. The cross appeal is that we believe the Hobbs Act should have been applied to the forward bolts as well as the aft bolts and the reefing line cutters. We recognize that there was evidence that the aft bolts and the cutters were in fact being held hostage and the forward bolts were not, so it's a more attenuated argument. We acknowledge that. But we also acknowledge that when you have a supplier engaging in this type of conduct, it was reasonable for us to be afraid that they would engage in this conduct with all programs. And there's no way we would have given them a new contract for bonnet thrusters, let alone leave our critical programs there. On the $57,000, contrary to what Mr. Christopher told you, you can look in the record, there was never an objection to arguing that as the measure of damages for termination.
Was there an objection to the admissibility of the interrogatory answer?
No, there was not. No, you look at the record, there was no objection. It was done, I read it, they had no objection. They asked that I read an additional portion of it, I read the additional portion of it, we moved on. No objection during closing either.
All right, sir, you're out of time.
Yes, sir.
Thank you. All right, I've already posted the extra 2 minutes on the clock there, sir.
Thank you, Your Honor.
What about the reef cutters? I read the contract language. I understand your argument on that whether you breached or not, you're still entitled to be paid for completed goods. He says you all just never argued that, never presented that theory. I know you had a motion for rehearing where you might have presented that, argued it to the trial judge, but is that issue waived?
I don't know, Your Honor. We certainly didn't intend to waive it. The case was tried on a straight up or down theory of, was there the violation of the Hobbs Act such that would, according to their theory, justify a termination for default. And if there wasn't on that case, then the only measure of damages was the termination for convenience measure. And going back to your question, Judge Cohen, on the Bolt contract where a directed verdict was granted in our favor on that was not a default situation, so the only measure of damages under that Bolt contract was a termination for convenience, which included all the other factors aside from just what invoice or progress payment might be outstanding at the time of the breach. With respect to the breach and question you were asking, Judge Torpy, about when did this occur, I would direct your attention to the contract, to the default provision. It talks about a notice of cure We never got a notice of cure in this case. If there was something that we were doing wrong or there was something they questioned, that there was some slow delivery, why didn't they send us a notice of cure? They didn't. Again, in this case, they tried to, and it's telling here how Mr. Levin says, we accepted these things later and we didn't declare these two contracts, the bonnet thruster contract and the non-disclosure agreement, which we gave you but never intended to perform, which is the classic definition of fraud.
Mr. Christopher, where in your brief do you talk about the notice of cure issue?
I'm not sure I mentioned that in the brief, Your Honor.
How was that presented below?
I'm not sure that that was, because again, there was no notice of cure, and the theory that the trial judge allowed the case to go to the jury on was, again, this straight up, either there was a default as a result of this violation of the Hobbs Act, or there was no default.
But Mr. Christopher, you can't make an argument for the first time on appeal. You know that.
I understand that, Your Honor.
I'm not sure it wasn't in your brief. I have a recollection that there was an argument about that somewhere. So I'm not sure that you're wrong. I think it might be in the brief. Did you put something in there about it?
It's not argued in the brief anywhere, but it is mentioned in the statement of facts in the appellant's brief.
Okay.
Not anywhere in the argument section. That's why we didn't respond to it.
All right, thanks.
What's neglected in this case, and again, what I heard Mr. Levin say today, and certainly below, was this is an extraordinary situation because United Space Alliance, all of a sudden we've wrapped ourselves in the flag, this is a space shuttle, and therefore we've got a unique kind of contract. Anything we tell you to do, you have to do without question, but we can willy-nilly disregard our obligations under the contract. That's a unique theory. There's no basis for that in the federal acquisition regulations, and that's the way that they bootstrap here this extortion claim. And it's just there's no basis in federal law for that, and this theory should have never gone to the jury. If you look at extortion in this case, as we argued below, if there was any extortion in this case, they were the extortionate party by sending us a letter and saying, we're not going to send you any more payments on your bolt contracts, even though we've received the bolts, they're fine, it's good equipment, we've got them in hand, we're not going to make any more payments until you send us reefing line cutters. If that's not connecting conditioning performance in one contract on another, I don't know what is. Yet they say that's the whole basis for our extortion. That we're saying we won't deliver those reefing line cutters unless you award us a bonnet thruster contract. And I think that it would be a qualitative difference here if what I argue in the brief, and I'm not sure it's the proper characterization, but that we're legally entitled to that contract. In other words, that contract has gone through the normal procurement process, totally and completely unaffected by any of this other contractual wrangling by the other side of the United Space Alliance, and we win it, and we're entitled to it. And there's no question about that. And it's being held up for one reason. And that one reason is because they're trying to get these cutters from us. Again, who's extorting who here? This is just not extortion. This is what you see in an ordinary contractual bargaining position.
So it was extortion when they did it, but not when you do it.
No, I'm saying it's not extortion. There is no Hobbs Act thing. There is extortion. I'm saying if it was extortion when we did it, it was sure extortion when they did it, and they did it first. That points out the absurdity of this whole theory. If this is extortion, I would submit that virtually 99% of the businessmen practicing out there in our country today are extortionists. This is what happens when you get into contractual disputes or when somebody's trying to get more business and they say, okay, I'll fulfill this order that I've got with you quicker if you promise me that you're going to give me more orders later. Or I'll represent you cheaper on this case if you promise me that you'll send me more cases as an attorney or something like that. That happens all the time. That's not extortion. And it wasn't extortion in this case. And the federal case law is consistent on that. If you look, again, at the Icon case, Carl Icon, that's not green mail. I mean, why do they call it green mail? Because it's blackmail using money. But they say that's not extortion. But somehow this is extortion? No, this isn't extortion. And it goes back to the fact of why, when you look at that U.S. Attorney's letter, he talks about the fact this whole extortion investigation, the OIG's office was put up to it by the Space Alliance's general counsel. And he criticizes them for that. And as a private party, they're not allowed to misuse and take the agencies of the government to gain them a contract advantage so that they can get the goods. And just as they candidly conceded this morning, we didn't declare these two contracts that we gave you, we didn't terminate them immediately. We didn't tell you that we gave them to you, but we really didn't mean to give them to you till a month later, because we wanted to get our paper out of there. They not only wanted to get the product, they also wanted to get our paper.
All right, so you're out of time. Thank you for your arguments. Thank you both for your arguments.